Don West. I'm one of the attorneys for Mr. Zimmerman. You see George over here?
How you doing, George?
And Mr. O'Meara's co-counsel on the case.
How you doing?
How long have you held your current position in JAG Corps?
October would be 3 years.
And you taught at Seminole State College, was it beginning the semester of January 2010?
Yeah, so it would have been from January 2010 time frame to probably, I don't know, May.
Was it just the one term?
Yes, I only taught one class, and that was it.
Mm-hmm. And what did you do after that?
Right around that time, well, I was also working as a PD. I was at the Public Defender's Office during that time, full-time as Orange County Ninth Circuit. So I went back to work, and I left for the JAG Corps for training October 2010. So I went back to work full-time to the PD's office, and then went off to the JAG Corps.
Were you working for the Public Defender's Office in January of 2010 while you were also doing the adjunct professor?
Yes.
I got you. Okay. Do you remember when you started with the PD's office?
So that would probably be November 2009.
Was that shortly after you became admitted as an attorney?
Yes.
Admitted to the bar?
Yes.
So that was your first job?
It was.
As a lawyer, was with the Public Defender's Office?
It was.
And then you took on the responsibility of the class as kind of a side job?
Yeah, you know, I hopefully one day I could be a law professor, and I like teaching. And you know, the cool thing about that job, teaching, was that a lot of the things that I have to know or had to know every day from my job as a PD was reinforced by educating others.
So when you made the comment that your approach to the class was really from a practical standpoint, you were talking about how this stuff works in real life?
To the extent that you can, you know, it's been said that there's law on the books and law in action. You know, anybody can tell you what a recipe is, but if you get in the kitchen and don't know what you're doing, you're going to mess up the recipe. So understanding the law and how it's applied, especially when you're dealing with crimes, is so different than anything else. Any fact or change in fact can change the outcome, you know, so that's what I meant.
So even though there might be thousands of individual facts, it could be just one or two that may have significance?
Well, no, all facts have significance. You generally look at things from the totality of the circumstances, but there's certain things that, you know, through case law have been seen to give more weight.
Sure. The totality of the circumstances is you look at the sum total of the evidence, I take it, and then also apply common sense.
Right. A reasonable person standard is what that's generally referred to.
In fact, interestingly, it's the reasonable person standard or the reasonable belief standard which squarely is part of self-defense.
Yes, you can say.
And we'll talk about that more in a minute, but the work that you're doing now,
yes.
Are you prosecuting or defending?
Prosecuting.
Just prosecuting?
Just prosecuting.
Do you have the opportunity to defend?
No, I do not right now in this position that I am, but the way the JAG Corps is set up, they put you in a certain position, and throughout your career, you move on to different things. Before being a military prosecutor, I dealt with administrative law, federal regulations, interpreting of regulations, giving legal reviews, things of that nature. So as you progress, they move you on in almost like a little circuit.
So that would include defending at some point, perhaps?
Possibly, if I chose it. The Army sometimes cares about what you want, and then sometimes it's just the needs of the Army. So wherever you're best suited, your skill set, and wherever they need you is where they're going to put you.
Is this your career?
I'd rather not comment on that right now.
Fair enough. Let's go back, though, a little bit to the class that you taught.
Yes.
You commented that the course book that you used, first of all, you didn't write the book.
No, I did not.
It was a book that was suggested or?
Suggested. I think the previous professor used that book, and when I spoke with the director of the legal department, they said, hey, this is the book that we normally use. You know, take a look at it. It seemed pretty straightforward, standard book that you would see in a criminal course.
But it was not Florida law.
No, not specifically. I think they probably maybe reference majority, minority of states, but I don't think they ever probably talked about Florida specifically in that book.
Oh, I was just looking for the other exhibits for a
So
second.
I have them.
Let me take a look and see.
Sure.
what we got here. So the textbook that you used,
Sure.
was not specifically focused on Florida law as much as it was sort of a general discussion of a great many topics within this broad subject of criminal litigation and procedure.
Yeah, but then, you know, I try to supplement that with other materials and things of that nature, discussion to focus them on Florida distinctions, because I felt it was important, you know, even with respect to other criminal procedures and things of that nature. I felt giving the students some sort of focus, concentration on Florida law was important, so I did that.
So, for example, in part of Exhibit 210, it's an excerpt from the book that says self-defense, and I'll have you just
Sure.
take a look. Just that this isn't a specific discussion of Florida's self-defense statutes or what has been characterized as stand your ground.
Negative.
So that's true, it's not.
Yes, that's true. It is not.
Okay. So your discussions then that would be more focused on the laws in Florida would have been in the class,
Yes.
not in the textbook.
Correct.
Okay. As a member of the Florida Bar, then you took the bar exam and
Yeah.
had to learn Florida law in addition to the more broad general principles.
Yes.
So you had an understanding of Florida law as it relates to self-defense, specifically because of the Florida statutes.
Yes.
Just for the jury's benefit, a statute is a law that's been passed by the legislature and
Codified.
codified. So
Right.
when we say a statute, that's what's written in the law book.
Yes.
So the law of self-defense is written in Chapter 776, Florida statutes.
I'm not sure the chapter and verse, but if you say so, yes.
Do we have it just to take a look? This is not a trick question.
No, it's fine.
Is it on your? We'll come back to that
Sure.
in a second. But the idea is that the laws that are passed by the legislature and then usually signed by the governor and then become law are known as statutes, and they're in the law books.
Yes.
And that then becomes the law of the particular state where the legislature has acted.
Yes.
and you are familiar, generally, again, I won't ask you the specific wording, but you're generally familiar with the law of self-defense in Florida.
Yes.
You talked a moment ago, for example, how the stand your ground had evolved from the castle doctrine.
Yes.
Stand your ground is sort of a nickname for the statute. The statute itself isn't titled stand your ground.
No, I don't think any legislators would write that such a way, but it's a nickname.
So the is the word codification? The codification of the castle doctrine became Florida's stand your ground law insofar as the use of self-defense.
You can say that, yes.
Okay. The castle doctrine is the notion that if you are in your castle, in your home, you are attacked, you have no duty to retreat, even if you can. You have no duty to retreat. You may meet the force with force to defend yourself.
Yes.
Am I right generally on that?
Yes.
And then by the evolution of that doctrine into what's been generally characterized as stand your ground, what it did, basically, was allow someone to defend themselves outside their home if they are attacked.
Correct.
Without the duty to retreat.
Correct.
Before that, if you weren't in your home and you were attacked, before you could use deadly force, you had to retreat if you could.
Yes.
If you safely could. So in other words, if there's an attack outside, you have to sort of assess the situation, decide.
Let me hear the rest of the question, and then you may approach.
Under the old law, with the duty to retreat, if you weren't inside your home and you were attacked, you would have to assess the situation and make a decision at that moment whether or not you could safely get away before resorting to force.
Yes.
You may approach.
Thank you, Mr. Carter. We're back. The discussion that I'm having with you now about the Castle Doctrine and this law that's become known kind of by the nickname Stand Your Ground was the part of your classwork that wasn't contained in the book. Is that right?
Yes, it was not contained in the book.
Because of your training as a lawyer, having passed the Florida bar, been admitted to the Florida bar, and indeed working in the public defender's office, you were using that information and your understanding of Florida law to talk about these issues with your classes.
That is correct.
Okay, so what we were talking about then was the evolution of the Castle Doctrine into what the legislature did some, like 7 years ago, 6, 7 years ago, something like that, into what's been known as Stand Your Ground. So
Right.
That's sort of the focus.
Right.
Okay. The Castle Doctrine was this idea that if you were in your home,
It's actually, yeah, same objection.
think a clarification needs to be made if his answers to these questions are based upon his personal knowledge in his profession, or it's what he taught the class. Can you make that distinction?
Say again, ma'am?
Whether or not your answers to these questions are based upon your knowledge as an attorney in your practice, or are they also something that you taught the class?
The evolution of the castle doctrine?
That's the question.
Yeah, that would be something that I hit on in the class.
And you may proceed. Objection overruled.
So what that means basically is that when you are at the council doctrine, when you're in your home and you're attacked, you don't have to worry about whether you can get away. You may meet force with force.
Right.
Sort of a. And then what happened when the statutes changed a few years ago into this what's been known as stand your ground, basically the castle doctrine of no duty to retreat was simply authorized in locations other than your own home.
Right. I think what happened is the presumption changed. You know, if you're attacked in your home, there's a presumption that you're in fear of your life. A lot of times attacks happen at night. You're scared. You've been woken up by something. So there was a presumption that you were in fear of your life. So that's how that came about. And then it extended outside of the home. But there wasn't that same presumption. That same presumption doesn't exist outside of a home. It's dwelling, residence, I think your vehicle is where that presumption is. But outside of the home, there wasn't that same sort of presumption. I hope that makes sense.
Well, I know you're taking us to school, so let me clarify a couple of things. You're suggesting that when the attack occurs in certain locations, in addition, is there no duty to retreat, but there's sort of a presumption that if it happens that you will be in fear for your life.
So if you're in your home, that's in your home, there's a greater indicia that that person had a reasonable fear of death or grievous bodily harm.
Okay, but if you're in your home and I don't want to go too far away from why you're here testifying today, but I want to clarify, though, that part of self-defense is, under any circumstance, the reasonable belief that you have to act to avoid imminent great bodily harm.
Oh, yes. No question to that. So
There's an objection.
I'm sorry.
My objection is that the framing of the question is counsel's version of the law.
Okay.
And
I'm going to sustain the objection and state to the jury at the end of the conclusion of the evidence of this case, this court will give you instructions on the law that you are to follow and apply to the facts as you find them. Your questioning needs to be as to what he taught the class, not a general discussion on what the law is.
Yes, ma'am. Thank you. So when you taught the class, what is the core concept of self-defense when you can use deadly force?
When you have a reasonable apprehension of death or grievous bodily harm. And the term reasonable obviously has two components. So there's a subjective component, meaning that I feel like I'm in fear. In my mind, I feel like I'm in fear of death or grievous bodily harm. But when stuff hits the fan, you're judged by jurors. And your actions have to meet a reasonable standard objectively. So whether or not a reasonable person in your position would have felt the way you felt.
All right, so what you would explain then to anybody that was there that day would be that on the issue of the reasonable fear, it's both subjective and objective. The subjective part is crawling inside the person's head to see what they were thinking and would it be reasonable to them that they would fear for their life.
Right, and that's why the totality of the circumstances are important. For example, if you approach me right now in broad daylight, whatever the case is, I probably wouldn't have that much fear. But, you know, the lights are out, I don't know what's happening, I feel someone grab me. Those are circumstances you need to consider and whether or not someone had a reasonable apprehension of fear.
So the first part then is trying to understand as best you can from the totality of the circumstances whether that person was in fear in their own mind. Did they think that serious bodily harm was about to happen?
Right.
And then you're saying then there's a bit of a shift. And then in order to see if that's reasonable, then the trier of fact, if you will, the jury then looks at this idea. Does it make sense that somebody in that person's situation, with all of the circumstances, would fear that they were facing imminent great bodily harm?
That is correct.
Nowhere in the discussion of self-defense is it required that the person being attacked actually be injured. It's really the issue of what they think is going to happen, not what's actually happened. Is that right?
I'm going to object again.
Okay. The court will instruct the jury on whatever the law is at the end of the case, and that is the law that you are to apply to the facts as you find them. Your discussion today is limited to what you have taught in the course.
Yes, I understand.
Mr. Carter, the presumption is that any question that I ask you today is either to clarify an answer that you've given, to explain the legal concept, or connected directly with the way you would explain these things to your students.
Right. I understand that.
I'm not going outside the scope of that.
Understood.
So what you just explained is how you would explain this self-defense concept works in Florida.
Right, and it's fluid. You know, the law as it applies isn't static. Like I said, any change in a certain fact can weigh differently in terms of whether someone acted reasonable. And you know, to illustrate that, I would put up examples on the projector. I would have YouTube videos and pause it frame by frame. Okay, what's happening now? You know, what is this person justified in doing? What are they not justified in doing? And so you can see that, you know, things can change in a matter of moments.
An encounter that doesn't appear to be deadly can turn deadly pretty quickly in your mind.
Oh, yes. Yeah.
On the issue of injuries, though, when you talk about that with the class and your understanding of the law, is that the focus is what's going on in the person's mind, not whether they have actually been injured. It's the fear of the injury, is it not?
It's imminent injury. Imminent fear. So the fact alone that there isn't an injury doesn't necessarily mean that the person did not have a reasonable apprehension of fear.
Mm-hmm.
The fact that there were injuries have a tendency to show or support that that person had a reasonable apprehension of fear. But the fact that there wasn't an injury at all doesn't necessarily mean there was a reasonable apprehension of fear. You know,
you don't have to wait until you're almost dead before you can defend yourself.
No, I would advise you probably don't do that. Yeah.
And I take it, when you're under attack, you never really know where that moment will be.
No, unfortunately, you don't. And that's not even something from our. That's something that I think a lot of the students grasped. You know, I think we've all, and they have all probably had situations where, you know, a tussle maybe became more than just a tussle. So things can change.
For example, things can change that a situation that may not have appeared to be deadly or the risk of great bodily harm at first can develop into that.
Yeah, and we also talked about imperfect self-defense, where you may have started out being the person that was attacked, but for whatever reason, you took it a step forward, and now you're the aggressor. So that dynamic between two people involved in a fight or a scuffle, that could change.
You use the term imperfect self-defense.
Right.
Is that the notion that sometimes the tables can turn?
It means that, or also means that the person acted unreasonably in countering the force that was applied to them or approached with them.
Hypothetically speaking, this discussion that you started, if I'm approaching you,
Right. So if you're approaching me,
and let's say that I push you.
yeah, it'll be a little extra if I picked up a video camera and knocked you upside the head. That would be a little extra, and that would probably be an imperfect self-defense.
So let me see if I'm clear. What you would explain then would be, for example, I'll use the hypothetical that we started here. So if you and I were facing each other, and I pushed you or bumped you, and you reacted in great disproportion to what I did, then it turns, and you could put me in fear for my life, and then I would have the right to defend myself at that point, even though, under the hypothetical, I may have started it.
Yes.
So in that situation, I would be trying to figure out what's going on. How far are you going to go?
Yes.
How much danger am I really in?
Yes.
And under that scenario, would it be reasonable that if I were screaming for help and you didn't stop over a period of 10, 20, 30 seconds, that I screamed for help, making it clear I wanted no part of this, then I would have then an appreciation that you weren't going to stop.
Judge, I'm going to object to the continuing and the specificity of the hypothetical.
Sustained.
Without the specific details that I'm talking about, that's what you're talking about in a sense that it really doesn't matter. The focus of the self-defense is at the point that the force is used. And it's only really a relatively minor consideration as to what actually started it.
Objection again as to counsel positing things.
Right, if you will rephrase your question, because you began it with the former hypothetical that this court sustained. So if you'll rephrase your question, please.
I will. I'll try. Thank you. When you're talking about what you call the imperfect self-defense, what you're really talking about is when you're involved in a situation with somebody, even if you start it, but the tables get turned, and then all of a sudden you're the one that's being attacked with far more force than you used. That's the scenario I'm talking about.
All right, so let's repeat back what you're asking. So, basically, in a sense, if someone initially feel that they were being threatened, and they countered that threat with a force that was disproportionate to the force that was directed towards them,
Right.
Yes, that would be an imperfect self-defense claim or imperfect self-defense scenario.
So even under that scenario, the person that may have started it with some lower level of force, and the table turns on them and there's a great level of force, a disproportionate level of force, they have the right to defend themselves.
Right.
Objection, again, we're continuing number one, the same hypothetical. Number two is too specific to.
I'm going to overrule on that one, and the answer was given.
I didn't hear the answer. Could it be read back? You agreed.
Yes.
May I have just a moment? Thank you, Your Honor. Captain Carter, thank you.
You're welcome.
Any redirect?
The self-defense law. The idea of claiming it when you, yes, Your Honor. The idea of claiming it when you have provoked the action. That enter into the discussion?
Objection, Your Honor. May we be heard at the bench?
Yes. You may proceed.
Thank you. If I could, you're talking about the imperfect self-defense. Is that
Right.
discussion of sort of provoking use of force? Is that included
Say again?
in your concept of imperfect self-defense?
Right.
Where you talked about from starting as an aggressor to moving to something else. Is that sort of provocation? I mean, is that the concept you're underlying with that, or is that not what you're talking about?
What I'm talking about when it comes to imperfect self-defense is a situation where you do not meet the force that, or the force that you are encountering, you meet that force disproportionately. It's excessive force.
So I guess then the ultimate level of force in these scenarios is deadly.
It's deadly force,
Like a gunshot.
like a gunshot.
No other questions, Judge? Thank you.
Thank you, Captain.
Thank you. May Captain Carter be excused?
Yes, Your Honor.
Anybody need a recess? No. Call you next witness, please.
Call Jim Krinsky, Your Honor.
Raise your right hand. Do you solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I did.
Thank you.
You may proceed.
Thank you. Mr. Krinsky, would you please go ahead and spell your last name for us? In particular, tell us where you are, or I'm sorry, where you work, and what you do.
The spelling of my last name is K-R-Z-E-N-S-K-I. And I'm the Administrative Services Manager for the Sanford Police Department. I basically oversee all the administration of the police department and report directly to the Deputy Chief.
And by administration, does that include the records that the department keeps and maintains?
Yes, I have 4 records technicians that report to me.
Okay. Sir, I'm showing you what State's Exhibit 212. Is this one of the types of records that you just referenced kept by the Sanford Police Department?
Yes, sir.
Okay. And you've seen records like that before?
Yes, sir.
And what is it?
This is a Sanford Police Department writer release form.
When does a person fill out a form like that?
When they request to ride along with a police officer.
Okay. And was this filled out by a particular individual?
Yes, sir. There is a particular individual here.
And who was it?
George M. Zimmerman.
And when was it filled out?
It was filled out, according to this, on 3/15/2010.
Okay. And does the person indicate whether or not they have a reason for wanting to go on these ride-alongs.
Yes, sir.
And what is that reason?
It states here, solidify my chances of a law enforcement career, I believe, a career in law enforcement.
Thank you.
You're welcome.
Your Honor, I'd move State's Exhibit 212 then. No other questions.
Okay, it'll come into evidence as State's Exhibit 212. Cross, please.
Very briefly, Your Honor, thank you. Morning, sir, how are you?
Good morning, sir.
You, of course, reviewed all of your available records to come up with the one time that Mr. Zimmerman sought a ride-along with a police officer, correct?
Yes, sir. We searched for this record. We have literally hundreds of these, yes, sir.
Sure, and there was only the one where Mr. Zimmerman did that back in 2010,
Yes, sir, to my knowledge.
never requested it again.
To my knowledge, no.
Were you aware at all in your records that Mrs. Zimmerman had responded after that ride-along, talking about the officer that he had rode along with?
Not directly, sir, no.
Not in any of the records that you keep, that when you're looking for that record?
No, sir.
Okay.
I didn't find anything related to this ride-along other than this form right here.
Okay. Then I have no further questions. Thank you, Your Honor.
Thank you. May Officer Krasinski be excused?
Yes, Your Honor, please.
Okay, thank you. Do you may be excused, sir? Call your next witness. Are we ready to bring the jury in? In a moment?
We're having an issue with the audio, Judge.
Okay.
I know this shocks everyone. Mr. Pleasance, can you hear me?
Yes.
Yeah, there you go.
Yes, I can hear you.
Because I cannot hear you.
Let me try this. How's that? Not working? Okay, I can hear
Can
you.
you hear me?
Yes.
Okay, I cannot hear you.
Try that. Speak again. Can you speak again?
Testing, 1, 2, 3. All right, I can't hear you though. That's the issue. Let me get with them, see if we can work it out. I'll keep the phone on. Lou, they can hear me. All right, try now.
All right, can you hear us now?
Well, it sounds like a joke. Yeah.
Sounds like what?
Exactly like it. Can you sing a Christmas song? If needed, maybe I can hook up my iPhone, so maybe that'll as well.
I do have a proposal. We can leave the phone on for the audio that way.
Yeah, as long as we can hear him, if he can only hear you through the
We'll do that.
phone.
I'll do that. think we're,
Get their, pull up my laptop and see if that works for them.
well, I have an alternate solution. You can hear us fine, right?
Yeah, I'm on the phone.
Well,
Okay.
we can hear him.
We can speak to you this way, and we can hear
Well,
you
we
fine.
can hear him. He can't hear us, is that
Yeah, we can.
You can't hear us through Skype, you can hear us through the
the phone?
It's just their speaker system and that.
I understand. We can actually just ask our questions through this phone call. Go ahead and have a seat at the camera.
Okay, we can do that. We're just gonna, oh, okay, I'm gonna turn this off.
No. Don't turn that off.
Oh, he's turning off the sound.
That was just my volume.
Leave your volume on so we can hear you, and you will hear us through the phone. Got it?
Yeah, I was turning down my volume.
Okay. We'll proceed like this. That work for you?
Yeah.
Okay. Thank you.
Okay.
May I proceed? Yes, ma'am. Dr. Rao, using your definition of slamming, your common understanding of slamming, are the injuries to the back of the defendant's head consistent with having been repeatedly slammed into a concrete surface?
No,
Why not?
because if you look at the injuries, they are so minor that to me the word slam implies great force, and the resultant injuries are not great force.
What type and extent of injuries would you expect to see if the defendant's head had been repeatedly slammed into a concrete surface?
So if somebody's head is repeatedly slammed against concrete with great force, I would expect lacerations. I would expect a lot of injury that would bleed profusely, that would necessitate suturing, and so I don't see that in this picture.
All right, let me turn your attention to States 47. Were you also provided that photograph?
Yes.
And what injuries did you observe in this photograph, States 47, if you would, just describe those for the jury?
Okay, so there is a small abrasion on the bridge of the nose, right there. It's a very small little punctate at the tip of the nose.
Can you circle that with your laser, if you would,
Yes.
or just indicate it?
Right there
Okay.
and right there.
And are any injuries in this photograph life-threatening?
No.
Why not?
He has no loss of consciousness whatsoever. He didn't have to go to the hospital. He went to a clinic.
Were there any contusions or abrasions that you noted in this photograph?
Yes,
All right, can you, again, show us where those are?
yes. Right there and right there.
How would you characterize or classify the contusions, the severity of the contusions or abrasions to his face?
Very small.
Could all of the injuries that you observe in that photograph have come from a single punch or a single blow?
Yes.
And why do you say that?
Okay, so if you look at the distribution of where the injury is, and let's think that I'm the one inflicting the blow. If I was to punch myself right above here, I would get the injury on the nose and on the few contusions on the forehead. So one blow would be able to inflict these injuries.
Are the injuries that you observed to the defendant's face consistent with the defendant having been beaten a dozen times or more in the face?
If he was beaten repeatedly but with no resulting trauma on the face, then yes. But if the force is such that you get trauma, then only one time.
Did you observe contusions to both sides of the defendant's head?
On the sides, yes. Yes.
All right, let me show you State 75. Was that a photograph you were provided?
Yes.
And could you circle the area of contusion that you observed in State 75?
Okay. So one has to disregard this dried blood because it is coming from the laceration on the back of the head that I had demonstrated earlier. So we are looking at a contusion here, and there are very, very fine punctate abrasions that you need to have a close-up photograph to really see them.
And again, explain for the jury or define for the jury what's a punctate abrasion.
Okay, punctate means like a little speck, like a spot.
All right. Are any of the injuries depicted in State 75 life-threatening?
No.
And in terms of severity, how would you classify the contusions or abrasions in this photograph?
They are very small injuries.
Could all the injuries exhibited in State 75 have come from a single blow?
Yes, one impact against concrete, yes.
Let me show you State 73. Was that also a photograph you were provided?
Yes.
And what injuries are depicted in State 73?
Okay, so here again you have to disregard the dried blood that's coming from the laceration to the back of the head. And so you can see very, very faint, again, punctate, small abrasions.
Are any of those abrasions life-threatening?
No.
And how would you classify the abrasions depicted in State 73?
Very insignificant.
Could those abrasions depicted in that photograph have come from a single blow?
Single impact, yes.
All right. And why do you say that?
Because the surface area on the side, if you look at my head, and I was to get, on the concrete, I could get all those injuries from one impact.
You also mentioned that you viewed video clips of the defendant getting out of a police car and walking through the police station that evening. What did his appearance in that video demonstrate to you regarding his injuries?
Oh, he was not incapacitated in any way. He walked on his own power, and he was also conversing with the police officers during this reenactment.
All right. Thank you, Doctor. Judge, that's all I have.
Okay, thank you, Cross.
You got your appointment to your present position because Ms. Corey, the prosecutor in this case, appointed you, correct?
Correct.
Okay, so she's sort of your boss?
Not really, no.
But it was because of her. I mean, she appointed you to this position, right?
She actually sent my name up to the governor. So if you want to call that an appointment, well, then so be it.
Well, why don't we do this? I'm going to read a letter to you. Tell me if you consider this appointment. Pursuant to section 406.15, I hereby appoint... I'll approach and let her review it, maybe. I just have it electronically.
It's okay. I could explain.
Okay, let me ask the question.
Okay.
Is what I'm looking at a letter signed by Ms. Corey where she says that she appoints you to that position, yes or no?
That was the interim position. I can't say yes or no because I have to explain to you.
Well, I'll tell you what, I'll walk you through it. One at a time. I'll walk you through it, okay?
Okay.
There was a yes to that. She appointed you to the interim position?
Yes.
And you had another position as a medical examiner in the state of Florida too, correct?
Yes.
That was with the 5th District?
Yes.
But you were not reappointed to that position by the governor, were you?
I did not seek reappointment.
Okay.
It was
That was
tabled.
because, I'm sorry?
It was tabled. I did not seek reappointment.
And that was because of some of the problems that existed in your administration in that office, was it not?
Correct.
Okay. Yeah, you got the job with Ms. Corey's office, or actually in the same district where she prosecutes, correct?
She's a state, yes, yes.
How much of your work is on behalf of the state attorney's office in that district?
Well, the medical examiner really does not work for the state attorney. We are separate, but most of the time we are called by the state. However, the defense can call us. You could call me on this particular trial, and I would be here for you, just like I'm here for the prosecution.
Totally get that. My question was how much of your work is on behalf of the state attorney's office in Duval County?
All the homicides.
Okay. All the work, right? You only deal with homicides, right?
No, we do suicides, we do traffic accidents, we do drug overdoses, we do natural death where there is no physician to sign the death certificate. So it's other work. Homicides are a very small percentage of our cases.
I'm sorry, let me clear it up. How much of the work that you do involve crime matters? And I'm presuming in that question that all of your crime matters are dealing with the Duval County State Attorney's Office. So how much of what you do is related to criminal activities?
Okay, so we have a total of 1,165 cases, autopsies.
Okay.
And out of that, we are probably 110 homicides. So that is the proportion.
Okay. And in all of that work, you work with these very prosecutors, correct?
That is correct.
I mean, these are the homicide prosecutors for that division or that office, right?
Well, we have a whole series of state attorneys, yes.
Okay.
But they are in that office.
So they called you to look at this, correct?
Correct?
Did they have you look at anything having to do with Trayvon Martin?
No.
None
Well, they sent
whatsoever?
me the autopsy report, so I saw that, yes.
But you're not here to tell us anything about
No.
Trayvon Martin. You're just talking about George Zimmerman.
That is correct.
And if I get it right, it's your position that it's at least consistent that George Zimmerman may have only received as little as 3, did you call, what term did you use, smashing? Or
Sorry?
what, slamming. 3 slamming into cement, correct?
I didn't use the word slamming.
I'm sorry, I thought it was your word.
No, I got that from the reenactment.
What word would you use to describe what happened to the head that you say hit cement?
Impact.
Impact. So it's your position that there are at least 3 impacts between that head and cement.
Yes.
Okay,
Concrete.
concrete. However, and you said it's sort of consistent, so I'm going to walk you through some of that. I'm not going to use pictures right now. Let's just chat a little bit about it, okay? I think you used the suggestion that if you hit yourself in the nose that it could be all one shot, correct?
One blow. Correct.
Okay. You're not certainly just suggesting that it was only one blow, correct?
No, but
Okay.
consistent with.
And you say consistent with to minimize the number of shots that it could possibly be, correct?
Not minimized, but if you gave me another scenario, I could look at that scenario
Let me give
and
you-
see if it's consistent.
Let me give you this scenario. He gets hit in the nose like this, just like that, but it does not go up here. So here's the first shot, and here's the second shot. How many is that?
2.
Consistent with that picture?
It could be, yes.
Is it any more consistent or any less consistent than the fact that there was one shot?
I'm sorry, I didn't get
I'm
that.
sorry. You said earlier that those injuries could be consistent with one shot.
Correct.
And now I think you may have said it could be consistent with 2 shots.
If the way it's depicted, like you have depicted, yes.
Well, you don't, just so we're clear, you don't know how Mrs. Zimmerman was hit by Mr. Martin, correct?
Correct.
So you're saying it's consistent with 1, potentially, yes?
Yes.
And it also is consistent with 2, correct?
If the way it was portrayed, yes.
Which you don't know.
Correct.
So could you just say, is it consistent with 2 as well?
It could be, yes.
Okay. And it could be consistent with 1.
Yes.
Okay. And it actually could be consistent with another couple of hits with a palm, or, as you said, another couple of hits with a fist that just didn't leave visible injuries.
Yes.
So you're certainly not telling this jury that Trayvon Martin only hit Mr. Zimmerman in the face 1 time.
I'm just telling you what the injuries are and what it's consistent with.
Okay. Did you notice in those pictures the cuts on Mr. Martin's knuckle on his left hand, both on the ring finger and a slight one on the pinky?
Okay, those are not cuts, those are abrasions. So, because cut suggests sharp force injury, and they are actually where the skin is rubbed off on Trayvon Martin's hand. Correct.
That was a yes? You did notice them?
Yes.
Okay. Are those consistent with striking somebody?
Yes.
So we have some injuries, the only injuries, as a matter of fact, besides the gunshot wound, are 2 injuries on his knuckles, correct?
Correct.
Curious, since you've had a chance to look at the autopsy, were there any other injuries on Trayvon Martin at all?
No.
Any bruising injury?
No.
Any laceration injuries?
No.
Any punctate injuries?
No.
So you know for a fact that Trayvon Martin's head or any part of his body was not in contact with cement, correct?
Well, I didn't see any injuries. You can have a contact, but without producing trauma that's visible. So,
As Mr. Zimmerman could have, correct?
correct.
A dozen of them even, right?
Sorry?
A dozen even, correct?
A dozen what?
Other impacts. Well, let's get more specific. We've now talked about the potential of 2, you would even admit, let me ask you this. Is there a possibility that with a swat or a hit or a fingernail or something, that even this abrasion on his nose could have been a 3rd?
Anything is possible.
Well, you're here as an expert, so
Yes.
I want you to give us your opinion. is that possible based upon your level of knowledge?
Okay, so I will ask this. I know I'm not supposed to ask you questions,
Go
but
ahead.
you know. So then the next issue would be that each of the punctate marks on his head could have been caused by, you know, a fingernail scratch, or I mean that would be the next question posed. And we're looking at the preponderance of the evidence and the opinion rendered thereby. So, you know, we can continue this.
Let's move on. Let's move on.
Yes, okay.
But we'll spend a moment on the nose. So you saw on Mr. Zimmerman's right side there was a protrusion to his nose, correct?
What does that mean? I don't know.
I'm using the word protrusion. It was the first photograph. Let's go back and see if we can take a quick look at this. You see, you have, no, we both have one. You have a pointer, correct?
Yes, I do.
You see that spot right there?
That's the abrasion, yes.
No, right below, that little swelling spot right there. Do you see that?
I don't see a spot, but I see swelling, yes.
Swelling, I'm sorry.
Yes.
That swelling to an uninitiated view, actually it looks like there's a bone over there, doesn't it? But we know it's not, correct?
There is a bone, yes.
Well, but the swelling is not movement of bone, is it? Or is it?
I don't follow that. I'm
Let
sorry.
me just ask you to explain then. What is that swelling on the right side of the nose from?
Okay, so that's trauma, injury.
Okay. And what happens is the body reacts to it by rushing lymph fluid to it and all this other stuff. It sort of tries to take care of the site of injury or trauma.
Yes.
And that recedes pretty quickly, doesn't it?
Oh, it depends on the extent of trauma. Yes.
Well, and we know in this case, you acknowledge the trauma and the swelling there, right?
Yes.
And you notice in the pictures after it that the swelling has receded, correct?
Yes.
So it does recede after a few hours?
Depending on the severity. Here it was not severe, so the swelling rapidly declined.
And you know that there was blood coming out of the nose as he was standing up, correct?
Correct.
Where do you think that that was bleeding from?
From inside his nose.
And where would that go if he's laying on his back?
Where would what go? I'm sorry.
The blood?
Well, it depends. If you are alive, you would, if it went back in your throat, you would cough it out.
Or swallow it?
Well, I don't know.
Well, I mean, it's going back down your throat, isn't it?
Yeah, you'd cough it out. I don't know if you would swallow it, but maybe that's a good suggestion.
Okay. So we have the nose injury, one. We have the potential of the injury up here that you identified could be a second shot, correct?
It's possible, yes.
Well, I mean, if I showed you a picture, let's just say that we did, in fact, have a video. And the video showed a smash to the head, to the nose here, and then sort of an overhand. Let's say that it was an overhand shot. You had a video, or let's say an eyewitness, who saw an overhand shot. Would that be consistent, the overhand shot, with that injury up there?
The small bruise?
Yeah, right up there.
It's possible, yeah.
Well, is it consistent?
It could be.
Okay. On the back here, you testified that you believe that all this was created or consistent to have been created with just one strike on the concrete or cement?
Okay, so all this, I don't follow that. I see 2 lacerations and a small bruise.
Okay, you see this laceration?
Yeah,
You
but
see this laceration?
okay, so, it's being actually camouflaged by the dried blood and the dripping of the blood, but once cleaned, the nurse that examined him said one was 0.5 centimeters and the other one was 2.0 centimeters, which is very small. And so, after it's cleaned and you look at the photographs, you don't see what your suggestion may be that there are a whole series of injuries back there.
All right, well, I'm just going to ask a couple of questions about all this. You said, I think, in direct examination that this is consistent with one strike upon cement, correct?
Concrete, correct.
Concrete. Now, you're not suggesting to some reasonable degree of medical certainty that there was only one strike here, correct?
No.
So this could, according to where this was, let's identify a term. I'm going to use the term crown, and we know what the crown of the head normally is up here.
Correct.
But I'm going to use crown in a different term for the next few questions, okay? And that means the point that hits the cement. Can we use that term for just a couple of questions? Do you know what I mean by that?
Do I do what? Sorry.
Rather than the crown, which would be the first thing to hit the ceiling if you stand straight up, I'm going to say that, let's just say that this is where the impact on the cement is, okay?
Okay.
Now, the head could impact just there, correct? And just hit there, right?
Well, if the impact is on the side.
Absolutely, because we don't actually know what part of his head contacted the cement, do we?
We know that there are 2 injuries that resulted from the impact.
Right.
That's a given, right?
And they could be separate, right?
Except that it's in close proximity, yes.
Right. So I could hit a knuckle right there, but I could hit 2 knuckles at a time, correct? So it's according to how it happens, right? What the physics is of how it happens?
I'm not very good in physics, but we're not talking about knuckles, we are talking about one surface area. So I can explain just simply, I don't know about what the physics of this injury is.
Then let's get away from physics and talk this way. Let's just say that he was hit where, see this line right here? See that line? Do you see me making a line?
You mean the area?
No, the line I'm making with the laser.
Okay.
Okay, let's just say that only that on this side came in contact with the cement. Is that possible?
Oh, yes.
Okay.
It's possible.
And if that were true, that only the point on this side came in contact with the cement, that only that injury would occur, or could occur that way, correct?
It's possible.
And now, if we look at the other side, the same line, that side, let's just say that only this side of the skull was in contact with the cement. Then that injury would happen, correct?
That's possible too.
2 separate injuries, correct?
It's possible, yes.
You're not suggesting it's any more likely 1 or 2, are you?
So we are doing the preponderance of the evidence, and the preponderance would suggest that one impact is more plausible than the way the head is shaped to have 2 separate impacts. But if you say that was something that was eyewitnessed, then yes.
Well, what if somebody put their hand, let's say, on the side of a skull and smashed this way? Would that?
Fact's not an evidence.
I'm sorry, Your Honor, I didn't hear the
The
objection.
fact's not an evidence, sustained.
Well, let's just say that you have evidence that there is a fist getting hit down on one side of the head. Would you agree that the opposite side of the head would be forced downward?
It could.
If okay, so it could, right?
It could.
All right. And then that would cause an injury just on one side of the skull, correct?
It could.
And you see this bruising right here, do you not? See that swelling?
No, that's the shape of his head, I think.
So in your opinion, you've come to a medical conclusion that that crowning over there is natural?
Yes, that is the parietal area of the scalp, yes.
I'm curious why it doesn't seem to show itself as protruded on this side.
And sometimes the shapes of heads are different, we're not all symmetrical. And if you look, there is no discoloration there. So that may be an anatomic variation.
So right here, do you see any bruising or any discoloration at all in that photograph?
Okay, I don't see bruising, but I see small, very tiny punctate marks. And the other thing is, the photograph you're looking at, the hair is so short that if there was something there, we would be able to see it really well. And I have to strain to look and to see what you are suggesting. So I can't answer that question.
I just want to be clear because the jury will have not even these photographs, but they will have much better photographs to view and to study. But as I do that, I want to point out to you to see if we can focus you. Is it your testimony that this coloring here, this darkening in this way, is a natural occurrence on his skull and not evidence of a bruising? Yes or no?
I don't see a bruise there, but I did see, because I also have very good photographs, which you can see clearer. There are very fine punctate abrasions.
Okay. Let's speak a moment for what you do see then, the punctate bruising.
Not bruising, abrasions.
Punctate abrasions, I'm sorry. Is that the abrasions that you see over here?
Well, again, the photograph is so poor that, I have to look at my own photographs.
Then let's take a moment.
Okay.
Have some lights here on it. And I'm going to leave this up because it would be easiest for the jury, but let's coordinate, if we might, Doctor, the photographs you did look at and these photographs. May I approach the witness? Are you reviewing the photographs that you had?
Okay, so I will show you my pictures that I have. I printed them from the computer. So this is the one side. And this is the, I think, the photograph that you're showing, and you can see very fine little abrasions there.
Well, let's identify that you're now looking at a copy of what is State's Exhibit 73. And I think we're going to have to do this a bit more formal. So if I have a moment, Your Honor, I'm just going to have to get the actual 8x10s out of evidence. Going to try and do, Doctor, is to identify your photographs and connect them to the exhibits in. Did you get an entire picture packet from the State Attorney's Office to review?
No, I got a disc, and I printed out some of them because it was taking me so long on the computer, so I just printed a few of them.
Then we'll do it this way in case you don't have them all. May I examine her from this location because I've got exhibits that we do not have on.
Is the jury able to see in here? Yes, you may do so.
Let me show you what's in as State's Exhibit 69. Your Honor, these are in already, so I'm just going to identify them for the jury and have her testify from it. And let me ask you if you can look, first of all, let's identify, this is in fact State's Exhibit 69?
Yes.
Say, okay.
Yes.
You want to hold it for a second? Thank you. And I'm going to question you about that if you look at the photograph. Is it your testimony that in Exhibit 69 there is no bruising above Mr. Zimmerman's left ear?
I just see the punctate abrasions. I don't see bruising. And there are some marks on the head which are nevi, which are moles, brown moles. So you are seeing that also like there and there.
So, to point out, 2 inches above his left ear, this area of lightening and darkening you do not perceive as swelling?
No, I don't think that's swelling. I just think that's the shape of the head, but it's a very, very funny angle. And so there's distortion in that photograph, and I cannot tell you that that's bruising. I'm sorry.
Okay. And similar in States 57, so we're clear for the jury. In 57, sort of a back view, I asked you to focus first at the area we just looked at, which is about 2 inches above Mrs. Zimmerman's left ear. Are you suggesting that, again, that is not any type of swelling or bruising, but rather just the natural contour of his head?
Okay, so if you are suggesting that that's a swelling, then the bruise should be so marked that I should not have trouble looking and identifying that as a bruise. So I can't comment on that.
Is that a yes or a no? Do you say that that is bruising or not?
No,
Just above?
No, I can't see the bruise there. If that's what this part is what you're talking about, yeah, I can't say that.
Let me show you State's Exhibit 70, that's in evidence, which is a picture of the right side of Mr. Zimmerman's scalp, correct?
Correct.
And pointing your attention to the laceration, bruising, cut, use your term, not mine, just in the middle of that picture.
Yes, he has a bruise on the right side, plus he has the punctate abrasions.
Okay.
Yes.
The bruise on the right side, how do you think how did that occur?
Impact against concrete could give you that, and the other abrasions.
Now on number 70, let's look further back about 2 inches towards the back of his skull and tell me what you see there.
Okay. Are you referring to the small?
Yes, I am.
Okay, that is a small bruise. It's pink, discolored.
And is it your testimony how did that occur?
Impact could give you that.
And could that have been a different impact?
It's possible, yes.
It is possible,
It's
correct?
consistent, yes.
Matter of fact, how much of a distance do you think there are between those 2 points of impact?
Well, I think it's not just the distance, but also one has to look at the curvature of the head when you are, and when I'm giving you an opinion, I'm not only looking at the distance between the two contusions, but I'm also looking at the contour of the head.
That's what I was curious about, so let's talk about that. The contour of the head is somewhat sphere-like, is it not?
Oval, yes.
Oval. So if you have 2 points on a sphere or an oval, correct?
Correct?
It's convex, is it not, the skull?
Yes.
So if you have 2 points 2 inches apart, why is there not a continuous bruise or a scarring all the way across? Why would you have 2 separate ones?
Okay, so it's not scarring. Scarring is a different terminology.
I apologize for the misuse of the term. Why is it not one long, if it came from one contact, why is there not one long injury?
Okay, because the force applied to one area because of the contour may not be equivalent to the force in the other area, and so in one site the force may be sufficient to cause a contusion, but it's not. We're not like computers. It's not. You do something and you expect this result. We are dealing with a different configuration of the head, so. I don't think that follows. It's a nice thing to be able to say, but I can't say that.
Yeah. Certainly it could have been 2 separate injuries, correct?
It's possible, yes.
Okay. And looking at States 69, I want you to pay some attention to what seems to be a view of the Mrs. Zimmerman's skull, correct?
Scalp, yes.
Scalp. That's right. His skull will be underneath, right?
Correct.
And I want you to pay attention to the top of the picture and see if you can tell us what you believe that protrusion to be, my term, not yours.
Okay, so on the other side, we are actually looking at a photograph of the left side of the head and the top of the head, and we actually are getting a view on the right side of that bruise that we talked about. So that's the same bruise.
Do you see the swelling is my question?
Yes.
Okay. So there's swelling, and okay, you're suggesting, and I'd like you to be clear about this for the jury's consideration, that in exhibit number 69, you do acknowledge swelling that seems to be to the right side of the midline of the scalp, correct?
Correct. But you got the bruise, which, if you want to say, well, this is a swelling, but there is no bruising there. And if the swelling was so severe that you are looking at on the left side, then we would have a significant bruise, and we don't see that. Whereas there, it's a small bruise, but you can see the swelling. So
Yeah.
you can't separate one from the other. So it's together.
Look at number 70, which we've talked about already, and tell the jury which bruise you believe that swelling is connected to.
I think it's that one, because
You
it's,
think I just want to be clear, you're thinking to the one that is behind the ear. You pointed to the one that is 2 inches or so behind the line of the ear.
I think because that's such a distorted photograph that because we are able to see very well the right side. So why are we looking at a photograph of the left side and trying to draw that conclusion? I think that's extremely unscientific.
And I apologize for that,
No,
but I
it's
just
not
want to
your
be
fault.
clear about one thing. It is your testimony here today that the swelling that's on the 69 on the right side of the midline of the scalp, that is the bruising that is the same bruising as exists with what you've identified now as the bruising behind the ear line on states 70, correct?
It could be, but like I said, it's very difficult for me to to give an opinion on the photograph, which is so distorted.
Got it. Could it be a completely separate bruise?
Which one is
This
that?
one, the one on 69.
Well, if it was, why are we not able to see it from the right side?
Let's take a look at 71 then
Okay.
and see what you see on that photograph.
Okay, so this is again the punctate abrasions that I talked about, and that is the bruise that we have to overlap. I think that's the
And let me
photo.
show you just at the very top of the crown of the head there, almost out of the top of the picture. Is that not the bruise that we see, or the swelling that we see on 69?
I find it difficult when half the photograph is cut to give an opinion. I would like to see what the injury is before I tell you that that's the injury. So why are we looking at distortion and half photographs when we have the full side to be able to look at and to render an opinion?
Well, I certainly only want to do and have you give us as good an opinion as you can. Do you have a photograph that better shows the injuries that we've now seen by looking at 69, which shows the swelling that seems apparent?
No, I have the same, but I have just copies.
Okay, but that doesn't show the swelling, does it?
They're the same photographs, so how can they not show? Okay, so they are the same photographs, so how can it be different?
I'm asking you, as you're here today, to tell me what picture you have of the right side of his scalp that shows or doesn't show the swelling that was apparent in State's Exhibit 69.
Okay, so I have the same photographs you have, except mine is, like I said, copies. So this is the photograph that you are describing.
I'm trying to find the one that's in evidence for that, if I might have a moment, Your Honor. Let me ask you to compare, if you would, the picture that you were just showing with State's Exhibit, I'm sorry, let me identify it, 70. Do you have that one?
I'm looking. don't.
Thank you. So, the least number of contacts between scalp and cement were 3, correct?
Correct.
And as many as how many?
That's a scenario that you posed, so you would know how many.
Well, if you were to look at this from a medical perspective and try and come up with not the minimum number, but the maximum number, give us your opinion.
I told you 3?
That's the minimum, correct?
Correct.
My question is, tell us, in your professional opinion, how many it could have been as a maximum.
I don't know.
Why not?
Because you were presenting the scenario about various possibilities, so you have to tell me, and I will tell you yes or no.
Well, as I said to you, there could be a possibility that those 2 bruises were 2 different ones, correct?
On the head, yes.
2 bruises on the right side of the scalp.
Correct.
Okay, so I want you to include that. We also talked about the possibility that the 2 lacerations could be 2 different hits, correct?
Correct.
So I want you to include that. What other, and we talked about the nose and the forehead being 2 separate ones, correct?
Correct.
Okay, so keep going. How many other of those bruises could have occurred? Let's talk about the left side of the scalp. It has been your testimony that it is consistent with just the least amount of 1 strike on the cement could have caused everything on the left side, correct?
Correct.
How many could it have been more than that?
I don't know. You have to give me a scenario and we will say consistent or not.
Okay, he got hit 6 times on the left side of the skull. Consistent?
No.
Why not?
Because the injuries are so minor and they are patterned to some extent. So that would be beyond the realm, I think, of possibility.
4 hits on the left?
Well, if somebody is an eyewitness and says 4 times that this injury occurred, then of course that's the best estimate. So,
Okay.
you know.
Okay, so let's talk about 4 on the left side. You agree that would be consistent with the medical evidence, correct?
If it was witnessed, yes.
No.
But you can't just say 4 times and you're not seeing the injuries to match the 4 impacts slamming.
Listen to
slamming.
Listen to my question.
Okay.
Is there any medical evidence that would exclude the possibility that skull was hit on the left side 4 times?
That's not my opinion, but it could be. It's possible.
Okay. Nothing to exclude.
Nothing, sorry?
Nothing to exclude that as a possibility.
It's possible.
Okay. Now on the right side, the side where we see the 2 separate bruisings, we talked about that, right?
Yes.
And we also see the punctate bruising in front, correct?
Abrasions.
Abrasions.
Correct.
Anything that would medically exclude that the right side was hit 4 times?
It's possible.
Okay. We see 2 of the bruises, right? And they could be separate, right?
Possible.
Then we
yes.
see the punctate abrasions. That could be another one, right?
It's possible.
Then we see the swelling that you say may be connected with one of the bruises, but that could be separate, correct?
I don't think so, because underlying the bruise you have the swelling. It's so impossible to get a bruise and a swelling and say, well, that was 2 different sites. Now the swelling is separate from the bruise, yes, but they are 1 injury.
Okay. Presuming that the bruising on States Exhibit 69 and 70, that the bruising that we see matches up in the jury's mind with that point of swelling, correct? You're making the premise.
It does.
Okay. In your opinion?
Well, you can see it.
Okay. And the jury will, of course, make that determination, right?
Correct.
Okay. And then there could be how many maximum times could the back of the head have been hit on the cement?
Well, to me it was consistent with 1, but you suggested by turning the head in different ways. It could be 2. It's possible.
3 or 4?
With no injury, yes. If the head is in contact, producing no injury, yes.
How about the swelling below the lacerations? Did
The
you notice
contusion.
that?
The contusion.
Below, right.
The contusion, yes.
Could that have been a separate injury?
No, it's possible.
Well, if the head was hit so that just the crown hit the cement one time, let's say his head just snapped back and it hit here, that could have caused one of the lacerations, correct?
Yes, but it's
Okay.
so close to each other.
I-
That's the proximity that really kind of makes it possible.
Okay, I appreciate that. So if the head was tilted one way and then smacked back so that this was the crowning point, that would be one laceration injury, correct?
It's possible.
And then if the head was this way, another laceration injury, correct?
That's possible.
And then if I was able to resist one of the tossbacks of my head, I can actually keep the crown higher, and that back bruising that you just identified could have occurred, right?
It's unusual because, you're talking about a flat surface. So the head will have to be really contorted to be able to give you all those injuries from different impacts.
Change it now that it's not the cement, okay? Change it that it's here. Change it that what was hitting, that the bruise on the bottom wasn't flat, that it was against the side. Would that cause the bruising down here without the lacerations? Yes or no?
The side of what?
Side of the cement. You know that it was a cement sidewalk, correct?
Yes,
And you know that they were at the very edge of it, correct?
yes.
So you know that there is, in fact, an edge of cement, correct?
It's possible.
I'm sorry?
The injury is possible, like you are
Ah.
suggesting. Yes.
Well, here's the cement, and we've been talking and discussing as though all the injuries are on the flat surface, right?
Correct.
So let's introduce now that there could have been some injuries here.
Your Honor, object to that as facts, not in evidence.
Hypothetical with an expert overruled.
It's possible.
Okay, so the possibility is that the head being hit against the cement could easily, the 2 lacerations above may not have ever impacted again when the bottom bruising occurred, right?
It's possible.
Okay. Mr. Guy focused you on life-threatening injuries, right?
Correct.
Did they suggest to you in your testimony that this has anything to do with life-threatening injuries?
I'm sorry, I didn't get that. What is it?
Did the state attorney's office, when they prepped you for your testimony here today, suggest to you that life-threatening injuries was an element of anything having to do with this case?
No?
Okay. You understand that the extent of injuries are not significant in this case, do you not?
I'm sorry, I didn't get that.
Okay. You understand that the extent of any injuries that Mr. Zimmerman incurred in this attack have nothing to do with the case itself, correct?
Object to that as calling for a legal conclusion.
Rephrase your question, please.
I will. Were you prepared for the examination to identify whether or not you could testify that there were life-threatening injuries or not?
No.
Okay. None of these injuries that you identified as they turned out were in fact life-threatening, were they?
Correct.
What about the next injury?
The what, sorry?
The next injury.
What is that?
The next injury he would have sustained.
I'm sorry, I didn't get that.
Could the injury that he didn't have to survive, could that have been life-threatening?
Object to that as calling for speculation.
Sustained.
I might just have a moment, Your Honor.
Thank you. Any